So the next session is the procedures, that is the pleading, document, and evidence in the arbitration proceeding. Okay. Okay, let me explain the sequence of procedures, that is arbitration proceedings. So, as we all know, to invoke or to refer the matter to arbitration, there is a mandatory for arbitration, existence of arbitration agreement. So, and again, after the commencement of work and all, there will be a dispute. So, if there is a dispute and arbitration agreement, obviously the parties could refer their matter, refer their dispute to arbitration proceedings. To start with, the claimant, that is the person who initiates the arbitration proceeding, is called as claimant here. So first he will send a notice of arbitration invocation to the opposite person, that is who is called as respondent. So on the other hand, though the respondent replies or not, uh, after the lapse of some specific period of time mentioned in the notice of arbitration, the claimant could appoint the arbitrator, and the arbitration proceedings will commence. So once the arbitration proceeding is commenced, there will be a preliminary meeting wherein the parties and the arbitrator will be sitting together and decide the duration, that is the timeline for submission of documents. Okay, so what are the documents that will be submitted in the arbitration proceedings? First, there will be statement of claim by the claimant, and it will be followed by statement of defense submission by the respondent. And if the respondent wishes, he could also submit the counterclaim. You know, this counterclaim is very much general in construction arbitration. So equal opportunity is given for both the parties, that is claimant and respondent. So again, the next opportunity will go to the claimant to submit the rejoinder. And after that, the respondent will get another opportunity to submit a reply to the rejoinder, that is claimant's rejoinder. After that, there will be cross-examination of documents and a witness is present, and final submissions will be there. And once the pleadings and procedures are completed, the arbitrator will reserve the proceedings for order. So before going into the pleading submission and invocation of arbitration, you know, the claimant has to make sure that he has complete set of documents and the evidences which he wishes to refer to support his claim, uh, dispute. So this document may include, if it is a construction dispute or any kind of dispute, the contract agreement is very much mandatory, and it has to be duly, the contract agreement, it has to be duly signed and sealed. It should be duly signed and sealed by the authorized person. And if it is construction, the variation, if the claimant is seeking for variation claims, then approvals, inspections, and sometimes drawing related documents, communications, whether it is email or letters, he has to make sure that whatever claim he wishes to seek during the arbitration proceeding, he has proper support and evidential proof for all those claims. So first, let us start with a statement of claim. Yes, the claimant will submit the statement of claim, and it is the initial pleading made by the claimant in the arbitration proceeding. So it is the foundational document which outlines the claimant's case, providing a detailed description of the facts, legal basis for the claims, and the relief remedies sought. So this statement of claim, you know, it sets the stage for arbitration process, defining the scope of dispute and the key issues to be resolved by the arbitrator. So let us see what are the components which are very much essential to make the SOC a valid one. You know, there is no standard or legal framework for the statement of claim. There is no what is it? There is no legal steps that has to be followed to submit the statement of claim. Although uh, template which is being followed universally in the arbitration proceeding. So the components of SOC, it may include the introduction, outlining the facts of the case, and the reference to laws and precedents, and the prayer, that is the relief and remedy sought. So in the introduction, the claimant will be explaining in brief about the overview of the dispute, and he'll explain about the parties and the nature of dispute, the contract executed, and the summary of parties' position. Next is outlining the facts of the case. In this part, the claimant, of course, the counsel, will focus on the factual matrix. That is, in a chronological way, he will mention what has happened since the execution of the contract till commencement of arbitration proceedings. So, with all relevant events, dates, and documentation, the facts will be explained. Next is describing the legal basis of the claim. In arbitration, there is no specific requirement to refer to the precedents as well as law. Although to make the SOC a valid and appropriate submission, it is very much important to refer to the relevant laws and statute so that the claimant could support their position and provide a clear argument as to why the respondent is legally liable for the damages sought. And next, the end of the SOC will be the damages and relief sought. So a specific statement of the remedy or the relief of the parties be seeking from the arbitrator, such as damages, specific performance, or declaratory relief. This will be mentioned in this, end of the statement of claim. So what is the consequence of non-submission of statement of claim? The claimant is the person who initiated the arbitration proceedings, and he has to adhere to the arbitrator's order to submit the statement of claim. If it is not submitted, the arbitrator will give some timeline to submit his statement of claim. If the claimant is not submitting in the extended time also, in that case, the arbitrator has no other option than to terminate the proceedings. So before going into statement of defense, let me show a statement of claim for your reference. Sir, hope it is visible.
Mother, please close
Sir?
your Please close
Yes.
your PPT. Now you open that.
So now?
Now it is coming up.
Sir?
Yes, now it is visible.
Yes,
Yes,
thank
Madhu.
you, sir.
Okay.
Yes, so this is one statement of claim, that is a real statement of claim submitted in the arbitration proceeding. Here, first, the parties detail that is mentioned here, and it starts with the title, that is statement of claim. Here, the parties detail is being mentioned with reference to their address, residential address, and all. And the person who is mentioned, that is the claimant, I'm the authorized representative of the claimant. He declares his authorization here. And regarding the claimant, it is being mentioned, that is the claimant company, when it is registered, its registration number, and the nature of business, everything is mentioned here. And the current status of the claimant. In this case, the claimant was under insolvency proceeding, so that is being mentioned. And next is a brief detail of the respondent. So it is a private limited company, and the CA number is included here. And next, the contract detail, that is the dispute to which the contract is being mentioned here with reference to the contract reference number along with the date and the scope of work the survey, investigation, supply, the scope of work is mentioned here, and the value of the contract is also mentioned here. So from here, the facts of the case is mentioned since the beginning, that is with reference to the date since the start of the contractual execution. Everything is detailed here. Also, the claimant, whatever the documents he wishes to refer and whatever is relevant, he has mentioned and attached along with the statement of claim. For example, in this case, it is joint venture document. It is mentioned as document 2, and memorandum of understanding. It is mentioned as document 3. So whatever thing is being stated in the statement of claim, it has to be substantiated with the necessary and relevant proof. For example, if it is a joint venture agreement or communications or letter, it has to be attached along with it. So here the letter is being mentioned. This contractual reference number, the amount. So in a chronological way, the facts, whatever has happened, everything is detailed point by point. Also, the appropriate the documents are being referred. Okay. Okay. So the fact goes on. Yes. Okay. So in this case, it is purely based on the contractual dispute. So it is not need for the parties to refer to the precedents or the statutes. So hence it is not being mentioned. So the factual matrix ends here, and the relief and the damages claimed by the parties, it starts with the point 25, wherein they have asked for about 1036 lakhs to be paid, and interest they have mentioned, the cost of other expenses and cost of tribunal fees, etc. And this is the prayer. Okay. So in statement of claim, the limitation period, it varies from country to country. In India, we have a limitation period of 3 years to initiate the arbitration since the commencement of dispute. So that has to be detailed, stating that the statement of claim submitted is well within the limitation period. So that is being mentioned here. And the prayer is, and the statement of claim ends here. So now let us move on to statement of defense. So now the statement of claim is submitted by the claimant with all necessary and appropriate documents and evidences. So now it is the turn of the respondent to state about his contentions and objections and reply. Uh, this statement of defense is nothing but the statement of, counterpart to the statement of claim, where the respondent provide their version of fact and raises any defense and response to the claimant's allegation. And if the respondent have their own claim, in that case, they could also include counterclaims against the claimant along with the statement of defense. So let us see how to draft the statement of defense in detail. So following things has to be taken into account while drafting the statement of defense, set out the facts, jurisdiction, watertight defense, relief sought, and appropriate documents. Okay. In the statement of defense, you make sure that if you're drafting statement of defense, you make sure that all the relevant facts, whichever is favoring to the respondent, is being mentioned in the submission along with the appropriate evidences. And this statement of defense, once submitted, it could not be changed unless permitted by the arbitrator. Next is jurisdictional issue. I think you have been hearing about this term again and again. Yes. So if a dispute is being mentioned in the arbitration agreement, that has to be excluded while adjudication. So that kind of dispute cannot be adjudicated by the arbitrator, and it has to be excluded while deciding this decision during the proceedings. So in the statement of claim, if the claimant has mentioned something about a dispute that is being excluded in the arbitration agreement, and the respondent notices that, then he could highlight that in his statement of defense and object regarding that. And he could raise challenge to the jurisdiction at the earliest, and this could be also done at the time of challenge procedure also. Next is watertight defense. So if you're submitting a statement of defense, you make sure that all the points are being covered to make it as a watertight defense. That is, the statement of defense is an opportunity for the respondent to challenge the statements or assertions whichever made by the claimant and defend their actions, that is the claimant actions. So the respondent, by referring to the terms of the agreement between the parties, he could submit his defense statement. And he also could provide all the facts and terms of the agreement, which would help establish that the claimant is not entitled to the relief claimed. And appropriate documents. As emphasized before, whatever the submissions being made by the parties, it has to be substantiated with the necessary evidences, that is documentary proof, because the documentary evidence plays a major role in arbitration. So we have to make sure that all the supporting documents are being annexed and it is being referred in the submission. Okay. So let us look into the points to ponder while drafting a statement of defense quickly. So the statement of defense should deal with all the legal and factual issues raised by the claimant. The statement of defense must be to the point, and it should provide facts from the perspective of the respondents. It should justify the respondent's position. It should follow the chronological order maintained in the statement of claim, which means, in the statement of defense, the respondent will be answering to the submissions made by the claimant in the statement of claim. So whatever is mentioned in the statement of claim, it should be answered. Either it is yes or no. It should be answered by the respondent in the statement of defense. Next is complaints to requirements of the arbitral institutions, and attach all evidential documents. So whether the amendment to the statement of defense is allowed in arbitration? Yes. If the parties are requesting for the amendment, if it is ongoing proceeding, yes, the arbitral tribunal will allow if it is reasonable, and the arbitrator has the discretion to refuse such amendment if it is made, without any reasonable opportunities. On the other hand, the claimant also could request for amendment to the statement of claim submitted. So that is also being permitted in most of the nations in the arbitration proceedings. Yes, the counterclaim submission by the respondent, similar to the statement of claim, if the respondent have their own claim, so that is called as counterclaim. So this counterclaim is nothing but a claim made by the respondent against the claimant, effectively turning the tables and bringing their own grievances and claims to the attention of the arbitrator. So this counterclaim is an essential component of the arbitration proceedings, as it allows the respondent to assert their rights and seek remedies against the claimant. So let me display a statement of defense for you to understand more. So for the same case, is the statement of defense submitted by the respondent, which is Amrita Construction Private Limited. So first it starts with the party's title and the title of the submission, that is statement of objection filed by the respondent. The respondent detail is being mentioned here, and the counsel detail is also being mentioned here. And the respondent has mentioned that his statement of defense is filed against the relief that has been sought by the claimant in their submission. So in the initial, the respondent in the statement of defense, they will object to all the claims made by the claimant. So this is the general statement which is being followed. So the petition has been filed by the claimant with malafide intention to harass the respondent. These are some of the general statements which is being made in the statement of defense. And here, the respondent has mentioned regarding the preliminary objection, that is the main objection, which is being, contested by the respondent against the statement of claim. So since in this case, it is a contractual disputes, that is the joint venture agreement and memorandum of understanding agreement. The dispute is regarding these two agreements. So the case will be revolving and the submissions will be revolving on this. Here, the respondent has mentioned their own facts in chronological way, whatever their contentions. And they have also referred to the documents whichever they want to submit as a substantiated document. Okay, document one, the letter they have referred, brief facts. Yes. So here the respondent has given para-wise reply to the statement of claim submitted by the claimant. So for every paragraph mentioned in the statement of claim, the respondent has given their own reply. Yes. So para number 13, 14, 16. Yes. The defense statement ends here, and at the end, the respondent says that praise the tribunal to reject the statement of claimant, sorry, reject the claim of the claimant with cost in the interest of justice and equity. So this is the general words used in the statement of defense. Yes. So now let us move on to the next thing. Yes, the claimant is given an opportunity to submit the statement of claim, and the respondent is also given an opportunity to submit this statement of defense. So again, the equal opportunity has to be given to the claimant again. So that in that opportunity, the claimant will submit a rejoinder answering and giving reply to the respondent statement of defense and counterclaim if any. So again, on the other hand, the respondent will be given one more opportunity to equal both the parties. So here the respondent will give answers and reply to the claimant's rejoinder against the statement of defense and counterclaim. So with this, the parties will complete their pleading submission. If they wish to have submit more documents, and if they request the arbitrator for some timeline to submit their pleadings, one more, rejoinders. In that case, if the arbitrator feels appropriate, he will definitely allow the timeline. Next is framing and finalization of issues. So once the pleadings are being submitted by the parties, now the issues will be framed and it will be finalized during a hearing. So what is framing of issues? It is defining the specific legal questions the arbitrator needs to answer in the arbitration award. So these issues are framed based on the issue of fact and laws. Also, this issues, it clarifies what facts are relevant and burden of proof for each party. The parties, the claimant and respondent, they could propose during this hearing to frame issues. They could propose the issues that has to be included and answered by the tribunal. So let me explain this with an real-time issues. Okay. Uh, in Okay, in one of the arbitration matter and in a virtual hearing, the issues was framed and finalized by the parties and the arbitrator. Here, the arbitrator has finalized the following issues like first, the issues will be regarding the jurisdiction of arbitrator to adjudicate and pronounce an award and the validity of the agreement in question or the contract in question, and whether the claimant proves that the claims are stated in the SOCs within the limitation period. So that will be checked. And whether the claimant proves that respondent is liable to pay the pending amount of rupees. This is the claim amount in this case. And whether the supply agreement states about the interest to be levied in case of breach of contract. So whatever questions the arbitrator has to answer with reasons in the arbitration award, so that questions will be framed and finalized as issues during the arbitration proceedings. So these are the issues framed in this arbitration proceeding. Okay. So now the pleading submissions are over and the issues are framed. Next will be witness examination, that is witness affidavit submission and examination. So this witness affidavit submission, it is not a mandatory procedure, and this is being mostly avoided in international arbitration matters, even though in India it is very much prevalent. So here, the person whoever is being presented as witness, he will submit, that is reproduce pleadings containing the legal grounds of either party's case. So now let us go on to expert report. Hope you had come across to this I mean, expert report in some of your arbitration matters, etc. So, the expert report in arbitration, it is a document or the report prepared by a qualified expert who has been engaged to provide an independent opinion on specific technical, financial, sometimes legal, or other specialized matters that are relevant to the dispute. Um, as you all know, the arbitrator, there is no specific academic requirement to become an arbitrator. Even though if I have been appointed as an arbitrator for some complex contractual dispute, I don't have any engineering background. So in that situation, I may seek the help of an expert, and I could legally appoint him and ask him to submit a report uh, to on the dispute in hand. Not only the arbitrator, the parties are also being allowed to seek the assistance of expert, and their report could also be submitted in the arbitration proceedings. And this expert report is very much common in arbitration, particularly in complex construction matters. So, what are the type of experts and expert reports? Technical experts, these experts, they provide analysis and opinion on technical matters such as engineering, construction, architecture, and technology related experts. They are, if it is a construction dispute, they address issues like construction defects, complaints with technical standards, or the functionality of product, etc. So delay experts, you could have come across this term, and the experts, that is delay experts, they are professionals who are specialized in analyzing and assessing the delays in projects, construction projects, infrastructure projects, engineering projects, etc. Their expertise involves understanding the cause of delays, their impacts on project completion and timelines, cost, and determining the responsibility for the delays. So what they do is they will analyze with all the factual things happen and the necessary documents, and provide a report. Explaining the reason of delay and the party who is solely responsible for the delay in completion of the project. Next is financial and quantum experts. Yes, these experts deals with financial matters such as valuation, accounting, damages, and financial modelings. And their reports might include assessment of loss of profit, and calculation of damages, valuation of assets, etc. So if the arbitrator appointed, he does not have much financial knowledge in that situation, he could appoint an expert, that is a quantum expert, to analyze the damages and the monetary relief sought by the parties. Next is industry expert. Yes, these experts have deep knowledge of specific industries like oil and natural gas, telecommunications, etc. They could be engaged to provide insights onto their industry practice, standards, market conditions that are relevant to the dispute. So the expert appointment and expert report ends there. Next, we will go into written and oral arguments. So this is the final stage of the arbitration proceedings. The parties, they will be asked to submit written and oral arguments. So this argument will have the summarization of whatever we submitted in their earlier submission, like statement of claim, defense, etc. All those things will be summarized with reference to the issues framed. So this argument can be either orally or it can be in written, and this written and oral arguments, it provides a decision making roadmap for the tribunal. So while submitting the written and oral arguments, if you are representing any of the parties, you make sure that all your submissions, that is earlier submissions, is being covered in this written arguments. So the pleading submission and the arbitral proceedings ends with this written and oral arguments. Once this is completed, the arbitrator will reserve the case for award. So now let us see the type of evidences. Since the beginning, I have been emphasizing that uh, not only the submissions by the parties, the evidential proof to substantiate their claims and defenses, that is very much essential. So let us see what are the type of evidence which are being commonly submitted in the arbitration proceedings. First is documentary evidence. Of course, the documentary evidence plays a major role in arbitration because here in arbitration, the hearsay and oral evidence does not play any major role, and it does not have any weightage. So in the arbitration, make sure that whatever you submit, it is a documentary evidence, and it is not oral or implied evidences. So this documentary evidence may include the contract, correspondence, invoices, receipts, bank statements, photographs, and any other documents related to the case. So whatever the documentary evidence which is being submitted in the arbitration proceeding, it has to be duly authorized. It has to be duly signed and sealed by the authorized person. So some inappropriate documents, for example, the mail from unrelated person, or the contractual document which is unsigned, so that kind of evidences, it won't be considered during the arbitration proceedings. This is being explained with a case. In an construction dispute, the claimant submits copies of contract document, contract agreement, change orders, site photographs, daily progress reports, and email communications with the project owner to demonstrate delays caused by the owner's failure to provide timely approvals. So in this case, the claimant, the contractor, submits all these evidential proof, stating that owner, he is a person who is solely responsible for the delay in completion of the project. Next is factual witnesses. These are written statements provided by the individuals who has first-hand knowledge of the facts in disputes. So these are the person who are working in the dispute and the company. So this return statements provided by personal accounts and are typically sworn and affirmed to be true. So here in this case, the claimant, the employee submits a witness statement from the auditor, from the internal auditor, detailing the reasons for the claimant's loss due to the delay in contract execution. Next is expert report. Obviously, yes, the report by the expert, it will be considered as an evidence in the arbitration proceedings, and it may be of like technical, financial, and scientific reports. And whatever the report submitted by the experts, it will be an independent opinion, and it will not be influenced by either of the parties or by the arbitrator. So this factual evidence, it is submitted by the person who has direct and close relationship with the parties and the dispute. Whereas in expert report, it is submitted by the third person who does not have any connection with the parties, either with the parties, also with the dispute. So let us see the key difference between the factual witness and expert witness. The factual witness is the person who has personal experience or direct observation of the dispute happened, whereas the expert witness, he has specialized knowledge and training and expertise of the subject dispute. So whatever the evidence is submitted by the factual witness, it is purely factual and based on what they directly saw or heard. Whereas the expert witness, it is an opinion based and informed by the expertise and analysis. For factual witness, there is no specific qualification required, whereas expert witness, they require specialized qualifications and experience. Next is role in arbitration. Yes, the factual witness, they provide facts to establish what happened, whereas the expert witness provides expert opinions to interpret facts and the data. And the factual witness, they will be presenting their submissions to establish the factual context of the case, whereas in expert witness, they explain complex issues and provide professional judgments, and they help the arbitrator to render professional judgment. Next is examination of the witness and experts. Whatever the evidence or the witness reports, sorry, the expert report submitted, that will be examined during the arbitration proceedings. So that is called as witness examination. So whether it is factual witness or expert witness, first it will be examined by the claimant counsel. So that is called as examination in chief. And after that, there will be a um, examination by the respondent, that is called as cross examination. Next is physical evidence, this is not much common in arbitration proceedings, but it is still common in court proceedings. Here, physical evidence like the product, damaged items, or photographs, etc., will be submitted in the etc. will be submitted as evidence in the arbitration proceeding. Next is electronic evidence. Yes, in the digital era, the electronic evidence plays a major role. That is email communications, um, the electronic data, etc., plays a major role as evidence in the arbitration proceedings. Next is admissibility of evidence. So whatever the type of evidence submitted by the parties, the arbitrator is the final person who has to either admit or reject of the evidence submitted. So the arbitrator, he should ensure fairness and impartiality, and he should give equal opportunity for both the parties to submit their evidences, and should allow sufficient time if requested by the parties. For example, consider that in a construction case, either of the party says that the contractor says that the contract execution was delayed due to force majeure event like heavy rain for some period of time. To substantiate this force majeure event, uh, the contractor could get a report from the could a proper weather report from the authorized center to substantiate this for force majeure event. So for that, sometimes it may require some more period of time to get the document from the government authorities. So if it is reasonable, if the time sort is reasonable, then that kind of time and opportunity could be given for the party. Next is admissibility of the evidences. Of course, the arbitrator has the discretion to determine the admissibility of evidences, whether it is relevant or reliable and probative value. They may exclude evidences that is deemed irrelevant and prejudice or otherwise inadmissible. The arbitrator has the discretion either to allow or to reject the evidence submitted by the parties during the proceedings. So, based on the following factors, the arbitrator will evaluate the evidence um, based on the reliability of witness statement and the independence and expertise of expert reports. So that will be assessed and evaluated by the arbitrator before allowing such kind of evidences if it is made by the parties. And for the arbitrator to appoint his own experts, he will be looking into the necessary qualifications that is required, uh, necessary qualifications. Sorry, yes. Okay. So if the expert is appointed by the parties, the parties will look into the necessary qualifications uh, for the parties to appoint. Wherein, if it is to be appointed by the arbitrator, he will be looking into the proper qualifications before appointment. Because for the fees to be paid to the experts by the arbitrator, the parties they have to jointly pay the experts fee. So obviously, parties will look into the necessary qualifications and allow the appointment of the expert by the tribunal, expert appointment by the tribunal. And next is procedural orders. So you have come across this interim order, interim injunction, that is before the completion of the arbitration proceedings. Uh, Along with this, if the arbitrator feels appropriate, they could also address some specific issues relating to the submission of evidences, such as granting time extension, the ordering the production of documents, or ruling on objection to evidences. He has the privilege to allow and pass such procedural orders. So these are the submissions that are being made in the arbitration proceeding generally. As I said before, there is no standard procedure for submission by the parties. Although this is the template which is being followed in arbitration in general.
60 minutes, my colleague, she has managed to outline what are the vital submissions that will be made during the arbitration proceedings, starting from statement of claim or statement of case that will be done by the claimant who is initiating the arbitration. That will set out all the factual matrix. Also, what are the disputes? What are the remedies they are seeking? And what is his prayer? Also, it will cover the compliance, legal compliances. The important legal compliances are the limitation period, as rightly explained by my colleague. The limitation period is a vital element for invoking the arbitration, irrespective of which country you are. In UAE, it is 12 to 15 years from the date of cause of action. That is a legal word you should know. Cause of action. Cause of action means that is the starting point. If you take your construction contract, if you are a contractor, you are submitting a contractual claim and that is repudiated by the employer. So that is the starting point or cause of action. It is nothing but the date on which your claim has been repudiated by the opposite side. That is the prerequisite to invoke the arbitration. That is called cause of action. Without the repudiation of your claim, you cannot invoke the arbitration. Therefore, from the cause of action, your arbitration invocation that should be within the legally allowable limitation period. If it is in India, it is 3 years. If it is in UAE or in the Middle East jurisdiction, which are compatible to each other, it will be 12 to 15 years. So therefore, you must do your homework. That will be stipulated in the statement of claim. Okay. Also, you need to establish the cause of action because that is the kickstart for your limitation period calculation. Okay. These are the certain legal aspects you must be aware. So that also will be clearly narrated in your statement of claim. Once you submit, if you are a claimant, once you submit, then the arbitrator, he will allow reasonable time to the respondent to submit his statement of defense. Is nothing but counter to whatever stated by the claimant. So the respondent's statement of defense, it should be watertight. It should answer all the questions. No questions remained unanswered. So the replies should be based on the factual matrix. That is another hallmark of arbitration that makes the demarcation between arbitration and the court process. In the court process, all the arguments will be based on the legal aspects. Whereas in the arbitration submission, whether it is a statement of claim or statement of defense that must be based on the facts. When you rely on the factual matrix, whether it is statement of claim or statement of defense, your chances of winning are more. Also, the statement of claim will include the respondent side of the claim, that is called counterclaim. Once that is submitted, then the claimant will be given another opportunity to respond to the statement of defense and the counterclaim. And in the legal parlance, it is called a rejoinder. Okay, so you get familiarized with these legal terms. Not many, but it is mandatory when you aspire to become an international arbitrator. So rejoinder submission. And then once these submissions are over, arbitrator, what he will do, from these submissions, he will set out what are the issues. What is an issue? The question to be answered. The claimant, he must have raised so many disputes. So the arbitrator, in the list of issues, he will convert into tenable questions. Yeah, don't worry, Bindu, I have not displayed. I'm just explaining to the previous session, and then we will move on to the next session. Not to worry. So the issues, they are the list of questions to be answered. Okay. So why I'm repeating of what my colleague has stated is arbitration is all about drafting. If you want to excel in arbitration, you must be a master draftsman. Okay. So the drafting, that is the important ingredient of an arbitrator. Whether you are sitting on either side of the table, whether you are a claimant or respondent, it all depends upon how you are drafting your submission. From my experience, how we will do, whether we are a claimant or respondent. Of course, the claim statement, especially for a construction contract, that will be running into several pages. But we shouldn't get the arbitrator exhausted on seeing your submission. The adjudication process, whether it is arbitration or litigation, it is matter of how you are passively influencing the decision maker. Therefore, whether it is a statement of claim or a statement of defense, whatever you have stated in the several pages, you must give the essence of your submission in one paragraph to begin with. That one paragraph, that should state what you have presented in the several hundreds of submission. That is where your success lies, whether you are a claimant or respondent. Okay, so that is what I want to sum up and convey and append to what my colleague has explained to you in the last 60 minutes. Okay, so with that, we will move on to the next session.